I just have a few pictures of slides that we can quickly go through, and then we can go to questions and answers, get Judge Coleman back up here again. But originally we were taking the ferry 6:45 in the morning, hour and a half each way, and then we were in the charter plane earlier. So we're so unique here in Second Judicial Circuit with 3 islands that we serve. And when I got sworn in, I did a article that had to get approved through the CJ's Office and Administration about rural court access to justice and transportation and how we travel to Lānaʻi, Molokai, Hana. And the Supreme Court justices, Sabrina McKenna and a few other First Circuit judges called me up and said, I didn't know you've been doing that. And I said, well, for 40, 50 years at least we've been, right? So I'm all for getting the word out and how the rural communities are served and access to justice is provided. But we have the bailiff, the sheriffs, the judge, the court staff, the pilot, prosecutor, public defender. So next one. So ferry, plane rides, no trains yet. And of course you folks know that's where the old Lānaʻi court building and cell block and police station. You read closer to this sign, it says no person is allowed to be detained in this for more than 2 hours. But it's very historic, and I think that picture of the old court building made the Bar Journal article, which was shared with the whole legal community in the state of Hawaii. So a lot of people didn't know about this, and it's an important part to share. So next slide. And this is Hana Court, if you've ever been there, if ever seen it. But Hana Court also worked out the police station, courthouse, it's a community center, as well as we just found out this past couple months ago in the back room, there's a radio station. So we have to remind the radio station that every first Tuesday of the month we have some confidential but court proceedings going on, so we have to avoid disruption, and so they at least stay out of the court when there's trial arraignments, pre-trial is happening. And we're thankful to the Hana Community Center and Cultural Resource Center that's been leasing the building to the judiciary since who knows when, at least 30, 40 years for a nominal amount. So when our charter plane went down with that unfortunate plane crash on Lānaʻi, Captain Bill and his partner who perished in that flight, Captain Bill didn't perish, but that went our mode of transportation to Hana Court. So a survey was taken with the Hana community. Did they want to try to go to Haiku Community Center, come to Wailuku Court? And most of them, out of 99% of those polled said, no, we want the courts in the community to serve us rather than us making the trek out of the community. So Judge Cardoza feels important to keep the rural community courts open and serving the public rather than making arrangements. So we made the 2-hour drive to the time until Mokulele started chartering us there for our traffic court and district civil calendars. But Maui Mediation Service is driving out there as well to handle or assist in dispute resolution. So next slide. But with the plane rides to Lānaʻi, Molokai, we get some beautiful pictures, waterfalls, rainbows, and the fish pond local. But luckily we live Hawaii. We have all these beautiful sights and things to see when we travel to our rural areas. A few more slides. I used to give ethics training for public officials, but as judges, prosecutors, public defenders, we're all bound by the Code of Ethics, also the Judicial Code of Conduct, and Hawaii Rules of Professional Conduct. But the purpose, is in a nutshell, is so we can all, the public can have trust and confidence in the integrity of the profession. So those rules help keep judges, attorneys, public officials ethical. Okay. That just describes it. But it's important to have a fair, independent, impartial judiciary and to enhance the confidence in the integrity of the legal system. It's in the Constitution as well. And so those are just four major canons of the Code of Judicial Conduct. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary. So I know it was maybe a heartache and a headache and challenge in trying to plan this in terms of the funding and the grant funding and the donation, but we're governed by these codes of conduct, and I'm sure Judge Cardozo, that's why he said no, the judiciary will pay for it. We thank KK Network for their donation and their grant funding and going out and getting it to allow this, but we don't want to be questioned in any way in terms of these codes and canons that we have to be part of. And number 3, a judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with duties of the judicial office. And it all goes back to that purpose, so the public can have trust and confidence in the integrity of the judiciary or the office. Oh, there's a few helpful information on the handout too, and I can email you that. But the Self-Help Center, which Judge Holman mentioned a little bit, they're open every Thursday 9 to noon. They have the attorneys working that area pro bono, free of charge to members of the public. They can give you a referral or answer the questions that you may have, or refer you to an attorney. And Kauai has opened it up. Also, the First Circuit has attorneys and the Self-Help Center, but Second Judicial Circuit only is every Thursday 9 to noon.
That's the phone number that I was talking about.
Yes, this is the number.
So she's got it in hers, and that's the phone number that can get you the cell phone.
But ideally, hopefully, we can have a person or staff here. I know there's a question of judicial Lānaʻi court staff here, but it comes down to resources and positions that have to be approved and monies available. But until then, this is another form of assistance to the community if you have any legal questions that need to be answered. And the next slide, I think I have more of the Judiciary History Center, a little bit about that. That's in the Honolulu. And then the last slide, it has other helpful websites, organizations, information. Thank you.
Open it up to questions. So if any of you have questions for Judge Healy or Brendan, now would be the time to ask.
I have a number of questions, but I want to wait to see if anybody else does first. Hopefully my questions will be of interest to them as well.
I know that was a lot of information.
My sister-in-law in Honolulu, her and her sister are twins. They are in the social worker. So talking about children, they have to go into the house to take the child out and bring it out to be safety. Because I don't know what happened to the couple or the mother and father. They had to take it out from there with the policeman with her, take it out and take it to the court to see what was wrong with that situation. And come to find out, they couldn't find out what was wrong because the child was small and he couldn't talk. You know, and the thing is that when you're trying to get with the child, you know, talk to them, but they don't know what they're talking about. But they wonder why is it that the policemen come and take me away from my mommy and daddy. So she was doing it for several years until her time was up because she dealt with the court too as well. So now that she's out of that, she's retired already from that. See, the issue is that when they do this kind of stuff, they have to go more into detail investigation with the policeman, the court, the lawyer, the mediator, everything has to be all together. Then they have to compile all the information to see what they're going to do when they go to the court. To reason with the judge as well, the lawyer, but you gotta make sure you're swearing underneath the oath now.
Yeah.
And Tiwani,
Well,
you
you
had
don't
you
swear.
had a specific question for one of the judges, or?
I think Brandon can touch on it a little bit too, as well as myself, as well as Judge Pullman, but
Yeah.
with juveniles involved, if you commit crimes in front of them, either domestic disputes or if something happened, they charge that as a felony. So to protect the child, to not observe that, or to
Right.
make sure the child is safe, I'm sure the CPS agency would go in there and remove it temporarily pending a hearing. So, correct me if I'm wrong, Brandon, but that's right, right? I mean,
Yeah.
any crime that is committed by the parents in front of the children under age of 14,
Yeah, abuse of a family member in front of a child is considered a felony.
felony.
Um,
But, of course, the police or the child agency would probably need some evidence or reason to go in there to investigate, to remove the child first, right? Judge Holman specializes in family court and that kind of cases, and probably seen a lot of those times
Yeah.
where
One
that
of the,
would happen.
you can picture, that one of the biggest challenges as a judge is when you have a contested bench trial. And you are the person to listen to the testimony, listen to the evidence, and then make a decision. For example, on a child protective service case, there's been a removal of a child, and there's the social worker, the caseworker will prepare a report, will do investigations. There's special rules that apply in child protective service cases. One rule is that hearsay testimony, like if you ever watch Judge Judy, she'll say, that's hearsay, I'm not going to listen to it. That's somebody else saying so-and-so said this. But in a child protective service case, hearsay testimony is permitted by statute, so that there can be things in the caseworker's report, which is called the Safe Family Home Report, that will say, this is what was reported, this is what someone said. And based upon this report, I believe as a social worker, and the social worker is deemed an expert in their field, that there are safety issues involved in this situation, and that to protect the child from these safety concerns, the child for a period of time needs to be removed from the home. And the parents would have a right to a contested hearing in regard to that. And if the burden is not met, then the child would be returned. But it's, again, back, you can appreciate the position of the judge, listening to the testimony, wanting to protect the child, but also wanting to make certain that the rights of the parents aren't incorrectly taken away, even for a short period of time. One thing I want to say, with the court systems, what we do have is we do have due process, and people will ask, what's due process mean? Due process means that before anything happens to anybody's liberty or their property or their rights to their children or anything, that they have a right to notice that there's going to be a hearing, that there is a hearing, that the hearing is conducted fairly, and that the decision is done impartially, like Judge Healy said, with the ethics that the judges follow. And then a decision is rendered. So that's what due process is. Now, another term I would say would be perfection. And perfection would be the judge always getting it right. And unfortunately, that isn't always the case. And that is sometimes why the judges will encourage parties to see if they can work out an agreement. But you, as a judge, you wake up I'm sure Judge Healy does it too. You wake up, and as you're getting ready for work, you can picture getting dressed to go to be a judge. And every day I ask myself, help me do the right thing. You know, help me do this job right. And I think that every judge that I know in the Second Circuit takes their job very seriously, that we want to do the right thing. We want to make certain that due process happens, that people don't have significant things happen in their lives without having a chance to be heard, to have a chance to be listened to have the chance to bring witnesses, to testify, and decide whether or not they want to testify. And that is incredibly important to all the judges. And I know it's also important to the prosecutors, and it's important to the public defenders. And having met with your agencies earlier today, you've got some incredibly committed agencies here on this island that want to make certain that health of family is protected, mental health, physical health, the safety of children. It's a real honor to be involved in a process where you get to do your best to try and have the best outcome and the best result. Butch.
Over the years, many of our patients have gone to court and they meet up with their public defender 5 minutes before their time in court. What options do they have? Can they ask the court for a continuance so they can spend more time speaking with their PD and finding out what their options are?
Yes.
Yes, and the only restriction that the court is bound by, and the prosecutor mentioned earlier, the statute of limitations, but the court has to deliver a trial to someone within 6 months of the date of the citation or arrest or filing the complaint. So unfortunately, Lānaʻi doesn't have its in-house public defender or public defender here, and the first meeting usually occurs on the step house of the court building out there, and they have to serve the other 35 clients of theirs that morning before the 8:30 calendar while the flight arrives at 8:20. So it's not a good service for the client who wants to feel like they're getting that individualized attention. So don't hesitate to ask the court for another time to come back so they can give an ample amount of opportunity to talk with their public defender. And plus, at the initial arraignment and plea stage, a lot of the times the discovery is not ready or given to the public defender, because the public defender has to open up a file, get the information from the client first to open up a file to request the discovery from the police or the prosecuting attorney's office. So that takes a couple weeks in terms of time. So if you would like a continuance, don't hesitate to ask. The court would gladly give it and understands the restriction or the time restriction and not having enough time to meet. And plus we have to weigh that though in providing a speedy trial to that person, and we only come once a month, so you can ask for a continuance to the next day. But if continuance after continuance after continuance is not enough time to talk with your public defender, then that time of the speedy trial may count against the defense if it's the defense's request for continuance. But at least for the first time, we totally understand, and of course the judge has the discretion and will gladly give a continuance if more time is needed to talk to a public defender, especially if we never met them yet.
Yeah, and in the juvenile, and you can speak to the district court, but 90% of the juvenile cases get set for a pretrial. So the first return is admit or deny, and the way it will happen is the public defender will say, public defender representing juvenile, we waive a public or an out loud reading of the charges, we deny, and would ask the court for a pretrial. And then the court will say, okay, we'll receive your denial and we'll set this matter for a pretrial, so come back with your parents next time we're in court. On Lānaʻi, currently it would be 2 months from now. So there's a 2-month window in there. And so this continuance is kind of already pre-wired into the system so that there is a period of time between first coming to court, meeting your attorney, then getting the discovery, getting the police report. Years ago, I worked as a public defender, and I would always tell my clients, I don't want to even talk to you and hear your side of the story till I get the police report first and read you the police report. Then I want to hear what you say, but I want to give you the advantage of reading and hearing the police report first. And I think that's still how they do it. And so that stuff does take time. And so back to you, Adrian, but as far as the number of pretrials, not maybe on the traffic offenses because people just, but as far as more serious, 80–90% at least of county youth is probably about the same.
Yeah.
They go to a pretrial before there would be any.
Yes.
Yeah, I would say
Yeah, we
continue.
we have the luxury here, Second Circuit, of having pretrial, and that preserves the, I call it the sanity of the situation, because no one, including the prosecutor, wants the defense to rush into any type of decision. And so we're accommodating as well. If they need more time to consider something, we look at a defense or look at discovery, we're almost always going to give it.
I know you guys have it on Maui, but what's the protocol for requesting or using interpreters for the defendant here?
So
There's court-appointed, court-certified interpreters. There's the application process. I know with increase in the Marshallese, Pohnpeian communities, Ilocano, Tagalog, we have Office of a Language Assistance that has court certified interpreters available. And if not in person here on the island, we can call in and arrange that.
But if it's a contested hearing and there's a language need, there will be an interpreter.
Yeah.
And if the hearing needs to be continued to get an interpreter will be got. And sometimes in the initial returns, like you admit or deny on the juvenile or guilty, not guilty, sometimes we won't know that there is an interpreter need. And if there is a need there, we have a number that we can call and the court pays a fee for and has access to all kinds of interpreters that will then, three-way into the court by telephone and at least be able to give enough information explaining what's going on and when you need to come back to court. And then on that, when you come back to court date, then we will get a live physical interpreter.
Yeah, the Chief Justice has relayed to all the judges at a prior training that he feels important the language and interpreters are available in those people's choice of language. But if they can sufficiently understand the court's questionings and they understand English and they would like to proceed in English without the benefit of their first language, we make sure that they're okay with proceeding. But the Chief Justice stressed many times before the importance of having court interpreters available in the language, their first language if need be. And we have in the past, we have a Ilocano interpreter here in Lānaʻi, right? I just saw her on the ferry going that way. But she's been here many times. One time in Molokai, we had the Marshallese interpreter from the Wailuku Court building to Molokai Courtroom Polycom. But like Judge Pullman said, if it's a contested hearing or motion, it's best if the judiciary and arrangements are made by the judiciary to fly the interpreter in on that contested hearing.
And that's back to that due process word or phrase I was talking about before. Notice and hearing and right to be heard. Well, if you don't know what is being said and don't understand, then your due process is totally down to zero. So it's critical that people who need interpreters get interpreters. That's a high priority for the courts.
Yes.
Expungement, as far as what charges? Or any charges you can expunge from a record or in the process?
Well, there's two different types of expungement. There's expungement after the DANK, which is the deferred acceptance no contest plea. And there's also expungement if you're, that's the only type of expungement. You can be pardoned by the governor, but that's not the prosecutor's role. That would be between you and the AGs and the governor's office.
Okay.
Generally, if it's, you can't have been, I don't have the list in front of me, but you can't have been convicted of that type of offense before. It's generally limited to the less serious type of offenses. If it's a crime of violence or terrorist and threatening type of offenses, it's generally not able to have expungement from the record.
Okay.
Yeah, if it has an enhanced penalty as well, you cannot get a deferred acceptance. So if it's first offense is 5 days jail and second offense is 10 days
Now,
jail.
what if you take it to trial and then you actually win the case? Like,
Then you wouldn't have a conviction. It
Yeah.
would be a not guilty.
Yeah,
and they won't go on your record.
Right.
you would be considered
Nice.
acquitted. Yeah.
Because most job applications ask for convictions, right? They
Yeah.
don't ask for arrested. Have you ever been arrested? They ask,
Yeah.
have you ever been convicted of a crime? So it's a
Okay.
big difference, right? So. Beth?
Okay, you talked earlier about immigration, and I've been with you in court where you always say that this may affect your immigration status, et cetera. So is there some sort of guidelines or criteria that determine whether that person is more likely to be deported or detained or any of those things?
Brandon, do you know, and I know an immigration attorney would be better able to answer that question than me, but I heard maybe high-level drug offenses or felony convictions, but I cannot answer the specifics of that. But low-level misdemeanors, I'm unaware, and traffic violations, I'm unaware. But I would for sure, if the person is not a US citizen, speak to an immigration attorney, because that's a whole different process in terms of deportation and this sort.
And the public defenders can give advice to their clients as well on the consequences of being convicted of a charge. But generally, it's theft offense or DFS is not going to get you deported, but that's not ever a guarantee. It's up to the federal government, and it's a case-by-case scenario.
So, okay. And again, I've got like maybe 3 or 4. I want to make sure nobody else has a question.
I think you're good then.
Okay, well, okay. You talked earlier about eviction. So I got my eviction notice from my landlord. Could you please walk us through a typical scenario of what happens next?
There's 2 types of maybe eviction letters that you may get: a 5-day quit notice to pay or quit, and the other one is the 45-day notice that they're obliged to give you under the law, so you have enough notice to process before you lose your home. And once they file their claim for possession in the landlord-tenant possession civil court, it gets calendared, maybe after they serve them notice of it, due process notice, 3 weeks time. And that 45-day or 5-day may have gone and went, but they're gonna attach their 5-day notice to their claim, or they're gonna attach their 45-day notice to their claim, the landlord, and say, hey, we want these people out because we gave them their required by the law 5-day notice or 45-day notice. But once they get served with the complaint with that attachment, they are entitled to a hearing on it. The judge hears it, so that takes another 3 weeks, right, till they get served the calendaring of the case. And at the initial stage, if they fail to show, the default judgment will enter against them. The judge will give the landlord the writ of possession, judgment for possession, and the process server can have them removed from the property. So if you get served with a claim and notice of summons to come to court for that eviction process, you should go and at least answer. Your 2 answers possibilities are either admitting or denying. If you're denying, it may buy you some time, but the landlord also has a right to ask for certain monies to be deposited into the rental trust fund pursuant to law, and it's usually the back due rent that was not paid. And the court usually typically orders it within 2 days of the denial date. If it's not, then the landlord gets the writ of possession, judgment and possession in their hand, and they can have you removed. But that's why this, another option that I got involved with is in the state program to have these housing organizations, Catholic Charities, Maui Economic Opportunity, and other organizations available to answer questions that people that are faced with eviction may have, because it's hard to lose a home, but landlords do have rights too, right? Especially if it's governed by the contract rental agreement to pay your rent on time. If you don't, we have a right to remove you. So an eviction is I've been seeing increasing numbers of cases come and go, but it's important to fight the process. If you want to remain in your house, call an attorney, the self-help center, enter a denial. The general denial will preserve all your defenses to trial. The trial will be set or referred to mediation to allow maybe the landlord and tenant to have a neutral third party to help resolve the dispute. If they make this month's rent payment or half payment, we allow them to stay, to get them more time, and to allow that process to occur prior to just not going to the hearing and getting the landlord to get their eviction paperwork. So it's important to be a part of the process and speak to an attorney as well as if you're faced with those eviction paperwork. Hope that answered your question.
It does, thank you, thank you.
And I'll email you, Bev, that flyer that we had approved with all those important housing organizations on the back. And if you have any relevant ones that assist those here on Lānaʻi, please let me know, then we can tailor it to your community.
Okay, thank you. Anybody else, because I've got 2 more and I don't want to be the only one who goes.
I have another.
Okay, go ahead.
Talk about eviction. How do you deal with the homeless? Because they're there. Now, how you gonna get them from there to the affordable homes or to another place. Is that eviction too as well? You have to serve a notice or just tell them that you have to move another place? Go find another, what, underneath the road or underneath the highway or underneath the freeway. You know, I just came back from Honolulu. I see all this, oh my goodness, it's ridiculous. And yet, they can get one car over there, they have a motorcycle over there, and yet they cannot go work. You know what I mean? The thing is that, excuse me, you know, come on, get with it. You know, if you can afford it, go work. Then you don't have to live on the road. You don't have to live on the freeway. And that's make bad for everybody. The taxpayers paying for the place where they stay. You know, they're paying for the road. But the thing is that, how can the people from the big island come over here and live like that? We don't do that kind of stuff.
Especially in criminal court, Brandon and I have been seeing a lot of an increase in homeless cases, and with certain increase of homelessness, there's trespass charges, or the stores or the park or the establishments that don't want or ask them to leave because they're taking things from them and they get charged criminally. But eviction deals with people that have homes or rental agreements, or they're leasing places. But there's been a steady increase with the increase in population, including from those from the continent or that either come here or get sent here. And we've been seeing it in the past few months with increase in crime. But
trying to pass more laws that can try and address the problem, but the bigger issue is getting these people in touch with resources, which is sometimes not within our domain. But we do our best. We have possible diversion programs. If they have substance abuse issues, we try to give them substance abuse treatment that can address, which is really the underlying issue for the homelessness. If they have mental health issues, we have a mental health court in district court. It's basically a diversion program where they can go through the process and get treatment, get evaluated by psychologists and psychiatrists to get their issues addressed. And sometimes that may help resolve their homelessness, because the biggest issue is that they need to be back on their medication or need to have some sort of treatment.
and there's other homeless organizations, Kahale Akeola, that may be willing to house those that may not have a home. But it's important that the community get involved too, to assist in this increasing problem that touching all areas of our life. But did you want to comment? Do you have a more increase in homeless cases in family court at all, or no? I mean, there's been
That's your
increase.
Kuleana. I'm not dealing with that very much.
Any other questions, Beth?
Yeah.
Sorry.
Anybody else? Nobody's there? Okay. So this is for people who weren't at our meeting, because I think this is of interest. We talked about who can charge. So could one of you go over that again? In other words, I was arrested. The prosecutor's office doesn't get whatever they need to take it any further. And you had talked about like maybe the wronged party can actually contact your office in order to.
Yeah. So a complaining witness is a person that's gonna wanna you can call it press the charges if you want. Generally, like I said, the Lānaʻi police do their investigation. We don't do an investigation. So if you file a police report against someone for harassment and you want prosecution, you want the person to be prosecuted, or at least sent to us to review for prosecution, you need to tell the police that. And then the police will send that report to us once it's finished for screening for possible charges. For whatever reason, the report may not get to us. Sometimes it's just documented as a civil matter, or there's a variety of reasons why it may not come to us. So I always recommend that if you haven't seen any movement and you do desire prosecution, first thing is you have to have a police report. You can't come to us directly. That's the process to go through the police first. But once you have that police report number, you can call our office at the district court, give the staff the police report number, they will pull that report, intake it, and then it will come to me, and I'll assign it to a deputy to screen. And generally, we try to get those screened within the statute of limitations. Petty misdemeanor is 1 year, and a misdemeanor is 2 years. So if you are complaining with the case, you haven't seen any progress, call us, and we can try to help you.
In the interest of Judge Pullman doing the rest of his presentation, just one more, and I want to make this clear in my head. So I'm arrested on a Friday, and I should have my hearing within what, 48 hours? 72, which is it? 48? Okay. And because it's Friday, and I have to wait until Monday, can you explain that process again, how that goes? Or do I just stay in jail until Monday because it's my bad luck? Okay.
So like I said, there has to be a determination of probable cause within 48 hours. So if it's arrested on a Friday, the judge has to sign off on that determination within 48 hours, which would be by Sunday.
And that allows for the extended restraint beyond
Correct.
the 48 hours. So, and obviously court does business on Monday through Friday. So if you're arrested on Friday night at 11, unable to make the bail that is set based on the type of charge that you are charged with, petty misdemeanor, felony, DUI. The judge, the on-call judge, we take turns being the judges on call for the weekend to see which people we have to sign these extended restraint judicial determination. If there's enough probable cause, we sign it to hold the person to the next court business day.
So the way that works is the judge, if you're the judge on call, you'll get a call from the police department receiving desk, and they will say, we have somebody and they're going to expire Sunday at 10 in the morning. So you know, as the judge, you need to drive down to the police station before 10 in the morning and review the affidavit that's been prepared by the police officer where he describes what the person did that he believes causes the belief that the crime was committed, the probable cause, and the judge will read it. And then there'll be, after the judge reads the declaration, there'll be an order detaining that the judge will sign. And then they give the judges file stamps, so we get to act as clerks also, and we file stamp them filed in the court. So technically we're filing this in the court there at the police station Sunday morning at 11 o'clock, and we're signing it filed into court. We ask them to make a copy at the police station because they want their own copy, and then we take those declarations and those orders that these people be detained for beyond the 48 hours. They've had due process. They've had.
But there are times when the judge does not sign it. The judge does not find probable cause
Right.
for the
And
crime
if-
that was committed, and then they are to be released.
Right, right,
Okay,
right. And so it's like, it really, there's an actual process. I mean, it doesn't, these just aren't fancy words. Something really happens, you know?
And that's pursuant to Rule 5 of the Rules of Penal Procedure,
Yeah,
right? So.
yeah. Yeah, so the judges go to the police department, review these. If they find it, they sign it, they stamp it, it's filed.
Will you guys be open to being around a little while after if anybody would like to ask you a question one-on-one?
of course.
Maybe some people don't feel comfortable saying their question out loud. Let's give a round of applause to all of them. Thank you so much. We are ahead of schedule, and we still have another hour. So if you want to.
You know what I would like to ask is, we've really enjoyed today. I want to let you know that, both with the KK Network and as well as talking with you. You know, it's nice to be in the community and not just have that judge's desk in front of us, between us and you. So I know we all want to thank you, and we want to thank the KK Network. Butch Gima was really a spearheader of this. So we want to thank him and the KK Network, as well as you folks, for coming and giving us this opportunity to reach out to the community. It's really meant a lot to us.
Again, a round of applause for our guests, and thank you.
Oh, were you gonna talk about the?
He said he was going to take.
Yeah, I have a presentation about co-parenting, but the essence of it is that would involve parents with families where they are divorcing or paternity, and I make a big emphasis and I hope every judge does that deals with those types of cases, to most cases, generally it's in the best interest of children to have both of their parents involved in their lives. There are the rare exceptions where there are serious issues of domestic violence or substance abuse or mental health issues where sometimes the children need to be protected, and even in those cases often it would be appropriate for the children still to have contact, but maybe in a supervised, controlled situation. But 99% of the cases, as much as parents may not like the other parent anymore, at least they don't want to maintain a relationship, that doesn't mean that they don't have the children in common. And so one of the things I want to bring to Lānaʻi is we have at least a CD that's called The Purple Family, and it talks about families as they split up and how to do certain things to try and see the situation from the children's perspective for a period of time, and to follow certain rules, like don't put the children in the middle. Don't use the children as spies. Don't pass messages through the children. And on Maui, we have the parties there are ordered, if they get a divorce, before they can get a divorce, they need to come to court, and there's a 2-hour program where we talk about all of these issues. And there, as part of that, we show this video called The Purple Family, and that's about a 20-minute video. And I want to get some copies of that made, and consider the possibility of making it a requirement that a person says that they viewed the video. It won't be hard to monitor. It's going to be on the honor system probably. And you know, that is one thing I'd really like to get more service to the outer districts though with, which is, you know, these co-parenting concepts. But what I tell parents also, you can Google that concept. Co-parenting is the phrase. I suggest people Google co-parent and Arizona, because they have some really good committees in Arizona, psychologists and doctors who have put together a lot of good basic rules about how to co-parent. The other thing I wanted to talk about was at Maui Mediation Services, we actually have one of those co-parenting pamphlets will go by age, you know, what type of, how long can a child be away from one parent and with the other parent before they're disturbed? What types of things, you know, if it's a high conflict case, it might be better to have longer blocks of time with one parent so the parents aren't seeing each other as much. It might be good to have the parents do the drop-off and pickups using the school as the place to do that, so that they're not seeing each other in those types of cases. So there's these resources, and that's what I wanted to talk about. And I brought some copies of those, but today it's so, like, we're talking about what does district court handle, what does family court handle, but of the things that family court handles, one of the most important things we handle are the trying to find the best interests of the children when it comes to disputes regarding their parents. And I really do my best to massage the parents away from the dispute mode and move it to the co-parenting mode. So that was the...
I think any resources for co-parenting are needed. We come across parents in these situations all the time. I'm really happy to hear that Mediation Services of Maui will be able to come here, because I think that will be a great service for a lot of the cases that come before you, and also maybe just a starting point even before having to go to court. But time and time again, you definitely see those cases, those custody cases, where it's worrisome and for the children.
And the mediators that do the custody mediations are mediators that have been doing mediations a long time, and then they've also gotten additional special training regarding how to mediate co-parenting issues. And part of their training is I go talk with those mediators, and I tell them these concepts about not putting the kids in the middle and co-parenting. So I tell them, you tell these people these same things when you're mediating. They're going to hear it from Kids First program, they're going to hear it from you, and they're going to hear it from the judge, because I talk to them about it too.
When the mediation services said they'll come over, is that only in situations where you're court ordering that?
No.
Because there's been some, I think KK Network has tried to reach out to them before with Prevail there.
If you have trouble, let me know, because I've communicated and they said they will service.
Well, we'll just say that Judge Pullman said. I'm gonna drop your name.
I know what happened in the past is that, or one of the issues was, they don't have a place here, and Butch was kind enough to allow this one couple anyway to use his office, which I think we do as much as we can, you know, share our offices in that regard. But if that is a hang up for them, I'm sure we can, again, make something happen.
Thank you.
That's
Thank you.
the final thing I wanted to
But for
talk about.
mediation services of Maui, they've been really helpful, at least to attending with Molokai, Lahaina, and Wailuku, and even Hana, but they just would like advance notice of the need for them there in those rural communities. So what I did is I let them know or arrange with the staff, if you think that these cases may benefit from mediation, please invite the mediator today. And of course, if they have to fly to Lānaʻi or Molokai, they would need advance notice to fly out there. But one thing, in addition to what Judge Coleman said about kids first and best interest of the children and not fighting in front of the children, is, I think you said it in one of your orders, or maybe Judge Tanaka, that kids thrive in healthy environments, right? And when it's not healthy, they may not thrive in whatever area, and they may take it. It's so hard. And I commend Judge Coleman for being a family court judge. My father is a retired state family court judge, 20 plus years. But he said it was the hardest job that he had, dealing with families and disputes, but he for sure would hug us every night and come to dinner with us, and made us feel loved every moment that he was with us, because of the challenges and the hard things that he had to see every day involving families and children. I'd like to commend Judge Coleman for being such a great family court judge.
Thanks, Adrian. I think I said earlier, but I want to repeat, I think the Second Circuit has an incredible team of judges that are very dedicated and care very much. And all of the judges, I believe, are very, very honored and happy to serve the community. And we do see that as service to the community.